Here are the 3 tactics that insurance companies are going to use to lowball your case. And the third one could end your case before it even gets started. You've been in a crash, you're recovering, and the at-fault driver's insurance company calls you up. They sound nice. They ask, "How are you doing?" They even offer to send you a check right away to reimburse you for your medical bills. They aren't doing it to be your friend. They're doing it because they're running a playbook. Hi, I'm David McDivitt, a trial lawyer. If you've been injured due to somebody else's negligence, you should be able to just focus on your recovery. Unfortunately, you've just entered into a world of corporate strategy. Today, I'm pulling back the curtain on 3 of the top tricks that insurance companies use to pay as little as possible on your case. And you need to stick around because the third one on this list can derail your case instantly. Let's start with the oldest trick in the book, the fast cash lowball. Try saying that 10 times fast. I mean, I won't give you anything for it. It's not like Mr. Beast, but try saying it 10 times fast. Imagine you're sitting at home. You're in pain. The doctor's bills are starting to pile up and you are stressed out. The phone rings. It's the insurance adjuster. And they say, "Look, we acknowledge our driver is at fault and we want to do right by you. We'll send you a check for $2,500 today to cover your emergency room visit and get you back on your feet." It sounds like a lifesaver, right? Here's the trap. At that exact moment, you have no idea what your injuries actually are or how much your treatment is going to cost. Soft tissue damage, whiplash, disc herniation, future surgeries. These things can take weeks and even months to fully reveal themselves. You might think you only need a little physical therapy, only to find out 6 months from now you need a major surgery. When you accept that check, you have to sign a release. And once you sign on the dotted line, your case is over forever. The insurance company closes your file, and when that $30,000 surgery bill arrives 6 months down the road, they won't pay a dime. They bought their way out of a massive claim for pennies on the dollar, leaving you holding the bag. Trick number 2 sounds completely harmless. The insurance adjuster calls and says, "We just need to get your side of the story on tape so we can process your claim and get your car fixed. It's just standard procedure." Listen to this carefully. You are under no legal obligation to give the at-fault party's insurance company a recorded statement. Why do they do this? Because insurance company adjusters are highly trained interrogators. They're going to ask you leading questions, and one of their goals is to trip you up. They start the call by saying, "Hi, how are you doing today?" Now, out of pure habit and politeness, you're likely to say, "I'm doing okay, thank you." Boom, trapped. 6 months later, when your injury worsens and we later have to take your case to court, the insurance company lawyer is going to play that tape for a jury and say, "Ha, 3 days after this happened, he told the adjuster he was doing okay." Look, sometimes you've got to look at the insurance company like a bitter ex and assume that they're going to try to twist your words against you. Be polite, but always speak to your lawyer before speaking to an insurance adjuster. Let's talk about trick number 3. This one can derail your case instantly, and it catches people off guard every day. Another call from the insurance company. The adjuster tells you, "We want to pay your medical bills directly, so you don't have to worry about it. I just need to get you to sign this standard medical release so we can request the medical records from the hospital." It sounds completely logical, but if you look at the fine print on that form, it is rarely limited to just that crash. It is almost always a blanket authorization. By signing it, you're giving that billion-dollar insurance company a golden ticket to comb through your medical history for the last 10, 20, 30 years. They will dig up your records from college, your childhood, and your old sports injuries. And here's how it instantly wrecks your case. Let's say you have a severe disc herniation in your lower back from the car crash. If they dig through your history and find out that 10 years ago, you went to a chiropractor one time because you tweaked your back moving a piece of furniture, they'll say, "Look at this. He had a pre-existing back condition. This crash didn't cause his pain. That thing 10 years ago did." They will use your own medical history as a weapon to completely nullify your claim, leaving you zero compensation for a crash that wasn't your fault. Look, the bottom line is this. The insurance company adjuster always pretends and acts like they're your friend. But their real job is protecting their insurance company's billion-dollar bottom line, not your bank account. If you've been injured, do not sign anything. Do not give the other side's insurance company a recorded statement, and do not accept a settlement offer until you know the true long-term injuries that you've suffered. Trust your gut. If something feels rushed, it's because they want you to sign away your case before you have a true idea of what it's really worth. Speak to a local, experienced personal injury attorney first. Let a professional look over those forms so you can protect your health and your future. Thanks for watching. If you found this helpful, hit the like button and ring the bell to subscribe for more legal breakdowns. I'll see you in the next video.